watching Property TV.
Hello, welcome to Property Question Time. My name's Stephen Galpin, and this is the programme where you can have your property-related questions answered by a team of experts. And with me today is Azid Gungah, CEO of Quiddity Group. How are you, Azid?
Very well.
Good to have you back again.
Delighted to be back.
Byron Crellin, CEO of Clearway Debt Squared. Welcome to you, Byron.
Stephen.
Hope you had a good trip down from the north of England.
Yeah, sunny all the way.
Good. Well, it's even sunnier here today, isn't
Indeed
it?
it is.
So there we are. Okay, well, let's get on with the questioning. And Byron, you're going first. I'm a commercial landlord and gave written permission prior to the pandemic to my tenant to sublet their shop to another tenant. The new tenant was required to pay their rent to my legal tenant every month, and in turn, my tenant was to continue to pay me as per their lease term. However, the new tenant only paid 1 month after taking occupation and then stopped. My tenant has not paid any rent to me as a consequence. What are my options, please? Oh, apart from a baseball bat and Alsatian and whatever else you might.
I was actually thinking more of a kind of an easier question. Okay, so that's slightly. So we've got landlord, tenant as per lease, and we've got a subtenant. The subtenant there is a lawful subtenant because it's been recognised by the landlord. So what the landlord can do is the landlord can write to the subtenant and say, as the superior landlord, you now pay your rent directly to me. That's typically what a landlord would normally do to a lawful recognised subtenant. But if the subtenant has stopped paying, that would suggest that the subtenant and the tenant have got perhaps a disagreement, something maybe has gone wrong with the property, they've not been...
Wouldn't the subtenant argue that he doesn't have a relationship with the landlord other than the direct landlord that he's got?
He would, so the subtenant would recognise the tenant as his landlord. The true landlord, our client, our viewer, would communicate to the subtenant as the superior landlord and document that and say, here's a copy of the lease, blah, blah, blah. And therefore he can make a demand that all rent bypasses the tenant, so the subtenant passes and pays the landlord directly. I'm just wondering why the subtenant has stopped paying. There's obviously something there. What the landlord could do is forfeit the lease and terminate the occupation of both the tenant and the subtenant, and then negotiate directly with the subtenant.
I'd like to see that one before a district judge.
We've been there, and and the issue that you've got is the subtenant actually sometimes doesn't even know that there's a superior landlord in place.
Exactly, yeah.
Or
conveniently so.
We walked into a fast food takeaway pre-pandemic, and the individual that was on our warrant wasn't the tenant, and it was a turn of a card that changed the occupation. Still goes on.
Yeah.
I think that isn't there a little message here that kind of do things through your solicitor rather than give direct consent?
Yeah, totally, Stephen. I think the reality is that there's obviously a breakdown between tenant and subtenant. The landlord now is not getting anything from anybody. You could go to the subtenant and try and fix it and make them and do a re-assignment of a lease, etc. Or you could just basically say, right, cut it off, change the locks.
I think we've said on previous programmes, I mean, one positive outcome of the pandemic has been a better and more communicative relationship between tenant and landlords. I think has started to happen. But where you've got this sort of thing, where it looks to me on the basis of this that the first tenant has actually sort of been instrumental in arranging all this and probably just got permission from the superior landlord. It's not very satisfactory, and it's just heading for trouble, isn't it, if you don't do it properly?
It's messy. And of course, then you've also got potentially the arbitration process that you could now go through post-pandemic with the legislation. So as a landlord, and I think you mentioned a good point in terms of a lot of landlord tenants have now engaged even more so because the restrictions prevented landlords from having tools of enforcement agents to collect rent or to take possession, etc. So there's a lot more landlord-tenant relationship dialogue going on, but with that comes payment plans that are in no way crystallised contractually or recognised. It's goodwill engagements.
Yeah.
And sometimes that can be, if it's not documented, it can be missed and become messy.
Yeah. Anything to add, Azid?
I think I like the answer around trying to go direct, because we would do that. We would try to negotiate directly with the tenant themselves and see whether there is reason there, and if there is no reason to be had, then
there could be. The subtenant could actually be a good tenant.
Absolutely.
It's just the tenant in the middle could be the one that's going to create the issue.
Where you've got several parties, there's always a reason for something, isn't there?
Yeah.
So you know, find the reason and you maybe find the cure.
Yeah.
I think that's the issue, isn't it?
I like that, Stephen. Write that down.
Okay. Quite profound, yeah. Okay, Azid, your question. I own the long leasehold of my apartment, which now has 65 years to run. With the changes recently made or going to be made to the leasehold regulations, am I best to just let my lease run and leave renewing it to any prospective purchaser in the future, or try to negotiate it now? What are the pros and cons in relation to the cost implications?
Okay, so it's, again, multiple kind of faceted questions. So, so the change in the law around the leasehold has happened now. So any brand new leasehold that's going to come through that you'll buy today won't have a ground rent, or there'll be peppercorn rent. So because there's be peppercorn rent, there'll be no marriage value in the future. So when you come to extend the lease, well, actually, you'll get 999-year lease. Right. So in a few lifetimes from now, when you come to extend the lease, there won't be something what we all know right now is marriage value.
Yeah.
Marriage value is basically the cost that your viewer will have to pay and share with the freeholder. And how that marriage value is calculated would be as follows. So you've got 65 years. Anything below 80 years right now, you find it very hard to find lenders. So that's why a purchaser will either have to get a lease that's worth at least 120 years to buy it, but then that comes with a price, which then your viewer will have to extend that lease. To extend that lease, you have to approach the freeholder and negotiate a price. How does the price come about? You typically, and again, there's so many variations between lease negotiation, but typically the freeholder will get a surveyor to come out and actually survey the property and say, in a condition with a 120-year lease, this flat will be worth X. Today, it's worth Y. So there's a difference between that, between those two. And that's what typically is what the marriage value is. And right now, by and large, you will share that with, you will share half of that marriage value with the freeholder. So let's say there's a £50,000 marriage value, 25,000 you would have to pay the freeholder, plus on top of that, any ground rent increments that you would have to then top up. So let's say the ground rent right now is £50 a year, it's going to extend it by 100 years, you've got another £5,000 on top of the 25. So to answer the question around for your viewer, is it better to renew it right now or sell it as it is? I think the answer is pretty much, it doesn't really matter now, because if you're going to sell it at 65, somebody like me or Byron will come and buy it and we'll say, hang on, we're going to have to extend that lease. To do that, it'll cost us £30,000. So we want a discount on that. Or you extend it, you get you pay your £30,000 of extension, then you sell it with a full lease. What may happen is you get a bigger market to go for. So more, if it's a 1-bedroom flat, 2-bedroom flat, more first-time buyers can come in and engage with that flat and actually buy it. At the 65 year, you're tending to find investors, cash buyers who are not going to be able to access mortgages. So I would say it really is it is six of half and half a dozen.
Six of one, half a dozen of the other.
Thank you very much. That's what I meant to say. But yeah, so I don't think there's much difference between those two. If you sat on it, I think there is something now that we're waiting for existing leaseholds that will come into effect as a law, where ideally we're hoping that the marriage value will get scrapped.
Okay.
So we just don't know.
Are these going to be automatically now 999-year leases, all of them? Or?
So from today, any brand new build will have 999 years as almost a standard.
And what about a renewal? Would it go back to the original term?
So right now, any existing flat that you're going to renew will get your box standard 90 years, because the law hasn't changed yet.
Right.
If the law, as and when the law does change, hopefully this parliamentary session or next session, we would expect it to then change to, when you come to renew it, you'll get 999 years, as you will now get from a brand new one.
That would be the sensible way of doing it.
You mentioned about a surveyor. Is the surveyor acting on behalf of, who's the surveyor acting on behalf of it? And whatever the surveyor produces,
Yeah.
what happens if the other party goes, I don't agree with that?
Yeah.
Does it then go to like through a mediation process or?
Yeah, that's a great question. It's all about the interest of who's paying for what. So the challenge is when you're a leaseholder, you pay for everything. Yeah. You pay on behalf of the freeholder for the surveyor. So the surveyor can then dictate the freeholder can dictate which surveyor they go for.
Okay.
And then the surveyor knows their interest.
Yeah.
So they're working for the freeholder.
Yeah.
What we've done before is we've engaged twice. So we've engaged our own surveyor as well as paid for this freeholder surveyor. Costs an arm and a leg.
Yeah.
But at least you get some form of...
But once the formula is set,
Yes.
then the ambiguity goes out of it, doesn't it, really?
Correct. Yeah, and this is why we're hoping that the formula will be set also for existing leaseholds that are in place.
Okay, lovely. Well, great answer. Thank you both very much indeed. That's all we've got time for in this half of the show, so join me again after the break.
You are watching Property TV. You are watching Property TV.
Hello and welcome back to part 2 of Property Question Time. I'm Stephen Galpin and joining me are Byron Crellin and Azid Gungah. So, Byron, your second question. We are the landlords of an industrial estate and have a tenant who is constantly parking vehicles on the estate without permission. Can the panel please advise what enforcement action we can take to stop the tenant keep breaching their lease terms?
Yeah, this is quite a common offence that
clamping
we come across. The easiest solution and the recommendation I would give to the viewer is have you engage with the tenant, because the terms of the lease will say they may have a car parking space or 3 or 4 allocated to them as part of their demise, as part of the estate itself. Obviously, they're abusing that by parking vehicles across the estate, by the sounds of it. On that basis, my recommendation would be, in the first instance, engage, communicate to them and just say, look, no offence, but that's not allowed. Here's a copy of your lease, or refer you to clause X, Y, Z, and see if it rectifies, because that's the best thing to do. Landlord-tenant relationship, keep it. We've been through a bit of a traumatic 2 years, so occupation is king. So try and resolve it. But if they are a serial offender, then the options would be that you would engage a company like ourselves. We would attend, and we'd basically put a torts notice on the vehicles to say, move the vehicles or we move them. And that tends to be a solution. It breaks the landlord-tenant relationship. We've done one recently, and the tenant said that they were going to invoice their landlord because they'd had break in their electricity whilst the landlord was doing some work. So it's a bit of a trade-off, and it's like
tit for tat.
Yeah, absolutely. And it's like, well, we're not going to get involved in that, to be quite honest. The reality is you can't park your vehicles there, so just move them. Or we'll remove them.
Yes. Well, I think that comes down to the classic, doesn't it? You both sign the lease, so why don't we all just do what it says? That's the simple answer.
But surely that's common sense.
Yeah.
I mean,
well,
Stephen, come on.
Yes, leasehold and common sense are not always included in the same paragraph.
That would make our week boring.
We'll have a job.
Yes. Have you come across this on any of your properties?
To be lucky enough, we rent our car parking spaces to others, so we don't tend to actually. We'll probably give 1 or 2, but the rest of it,
pass the problem.
Give it to somebody else to manage. Yes.
Yeah, I think that's the way.
Because we're not expert in managing car parking spaces, so outsource it to somebody else.
Well, it's I mean, you see so many sort of ugly scenes, don't you, of car park enforcers having terrible engagement with the driver. And I mean, if you're not skilled in that sort of business or that sort of relationship, then
we have a lot for developers where they'll contact us and say, we've got this site, we've flattened it, and it's basically going through its process now, for designs, etc. We haven't started drilling yet as such, but people are using it as a free car park. And so we're going to start work next Wednesday, but there's 20 cars on the car park, but it's not a car park, it's not official. So what's our options? Similar scenario is torts notice, but you just think educationally, right, these people are probably commuters. If we get on site for 6:30 in the morning, park a vehicle across the access point, and then just stop them and say, here's a notice to say this is private land, it's not a car park, turn around, don't use it, and actually there's going to be work starting here.
You usually only have to do it once, don't you?
Correct,
Yeah.
correct. It's just using a bit of intel and,
All right. Azid, on to your question, and I'm just going to say part of my job is to watch the timing of this programme, and I think I could probably spend half a day with you on this on this question, but so if you could just be mindful of that. I have 2 freehold blocks of apartments which provide a steady and safe income for me from the ground rents. I've read in the trade press about title splitting as a way of enhancing income from freeholds. Can the panel please explain how this works? Now you know why I gave you that preamble.
When Stephen says panel, that's you.
And now I'm assuming you're saying because of time, because I could go on and talk about this. I'm a man of many words, not few words. So, but suffice it to say, you know, I've said it before. I mean, I've written a book about title splitting, so I'm very well versed with the strategy. But in essence, the strategy is you're basically buying freehold blocks, which my company does, and then we create new leases out of those freeholds. So in the case of the viewer here, the assumption I'm making here, freehold block, 2 flats with the ground rent that, you know, he can then, obviously he pays himself to another company or whatever, because the idea of, there's key fundamentals about title splitting. One, that when you do come to split the title, your freehold and your leasehold can't be owned by the same entity.
Okay.
So typically we have 2 different companies that hold the freeholds and the leaseholds. So the value bit. So does it make sense for him to split titles and create value? In my view, I would say, you know, depending on the price he pays for the block itself, there's always value. We just purchased one last month at 200 grand value, but there's huge value to be made because we bought it at the right price. It's the adage of property. It's not what you're buying, it's how much you pay for it.
Let me just stop you there. So let's get this principle correct. So
Yes.
we take a freehold house that's perhaps been converted into 2 or 4 flats, which have been rented out on ASTs, shall we say?
Correct.
You know, minimum 6-month lets, whatever, short lets, in other words, rather than long lease.
Yeah.
So you would then buy that block.
Yep.
And instead of carrying on with the short-term letting, you would actually create a title for each of those 4 flats.
Yes.
And then sell the long leases of those 4. And presumably the sum of those 4 comes to more than the sum of buying the freehold with the roughly converted
with
flats.
one of the freehold. So 90% correct. Yes. So we would buy the freehold, split them because it's already split anyway. I mean, we buy things that are already split with the utility splits. There's some nuances that you can save money on, but you would buy the block and then divide them on the legal paperwork into leaseholds. My personal preference is we split them, we refinance it, we hold them. But other people that I coach, they will then split them, sell each of them. Let's take a number. Let's say we buy at 500,000. There are 6 units in it, you know. So when you come to split them, well, let's say 5 units, so £100,000 each. You're paying for each one of them. When you come to splitting the title, you increase the value by refurbishing the usual development kind of works you would do. That adds value to the actual unit. So let's say now you come back and you want to sell it on the market. They're worth 125,000 each. So you've added 5 times 125,000. You've added 125,000 on that same block.
Okay.
Let's make it 25,000 pounds of spend to get there. So you've made literally within a few months of work 100,000 pounds in that case.
So look, just to drill down on that a little bit, to create 4 separate titles, say within a freehold house, what would be a sort of rough solicitor's cost on that?
So on average, we pay about £1,000 for one creation of lease, freehold, and all the kind of the legal paperwork that comes with it.
Okay. Any stamp duty implications on splitting the title?
So again, depending on the company group structure that you have, there isn't. So you know, I run a coaching program that I talk about what kind of company structure you need to have, so that the first company buys it, but then because it's intra-group transfers, there is no second kind of phase of stamp duty.
Just stamp duty there. Okay. And what about planning consent? Where you've divided up a freehold house just to let on short-term lettings by room or shared bathrooms or whatever else. And I'm not talking about a sort of HMO situation. I'm talking about just say 3 or 4 flats in one. Do you need any planning permission to split those titles?
Yeah, absolutely. So I would very rarely buy or advise people to buy something that has not got planning permission. Having said that, I've done quite a few of them, as long as you know what you're doing. So you can go back retrospectively, apply for certificate of lawfulness, which then goes back and says, okay, these work were done 30 years ago, building controls come in, surveyors come in, they see the structure's fine, they sign it off. That takes a while, it takes a certain skill. But normally I would advise people to buy blocks that already has gone through the planning permission process. So there is planning permission for those 4, because when you come to sell it or refinance it, the mortgage company or the buyer's mortgage company is going to ask you for that.
Right. Okay.
And then you're going to be, you won't be able to sell it, or you'll have to go and rectify it.
Okay. That'd cause you a bit of problem collecting the rent, wouldn't it, eh?
What a nightmare. I think I need to buy your book.
Yeah, but done correctly though, Stephen, I think is one of the best underutilized, talked about property strategies that I've certainly come in the last 20 years.
It's fairly risk-free, isn't it?
Is there not a... We have, when we're pursuing a debt, we'll look at, if it's a company debt, we'll look at the director, and if then the assets belong to another company, but it's the same director, we'll say, we can take the assets because you've had the benefit of the profit from having those assets in that property.
Yeah.
And we've successfully used that mechanism. Is there something that a solicitor would say, it's still you, irrespective of if it's a subsidiary of another company, that they could do a drag clause back? I'm not suggesting that the infrastructure that you've just explained.
Yeah.
I have to say, clear as mud for me, because it's not my space.
No,
but
of course.
I'll buy your book.
Yeah.
But is that something that could be challenged in the sense that there is a director, but that director is an officer of multiple companies, so it's then becomes a bit of a web?
It depends who is challenging for what reason, I guess. If it's financial mismanagement or whatever, my assumption I would make is yes, you probably could tie them together and say, well, hang on, the group company is owned by the same person. Yeah. And then there's limited companies underneath the umbrella, but ultimately it's still the same.
Yeah. But Azid, I mean, isn't that sort of a classic case? You're claiming it's a group situation on one hand to say no stamp duty.
Yeah.
So you've got to accept the group responsibility throughout the myriad of companies, right? But there is the protection. I think if I'm right, you would know better than me, but I think if I'm right, that sort of asset chasing can only go down. It can't go back up, can it? It can only go to subordinate companies, not back up.
Right. Maybe different sectors. If from a commercial debt, we'll go up. So we'll look at say for instance a commercial tenant in occupation, in arrears. Have we got a cross guarantee?
Oh, well, that's a different,
If we haven't got a cross guarantee, but that director has all the assets in another company, but those assets are in the demise, we will then go against that company and say you've had the benefit as the individual. You've had the benefit of both.
All right. Okay. Well, on that happy note of asset chasing, which I don't think we'll get too deeply into. Anyway, look, I'm going to thank you both very much indeed. Byron, thank you for your contribution. Azid, thank you for coming back and giving your wisdom to our viewers. So that's all we've got time for in this particular show. So I'm Stephen Galpin. Join me again next time on Property Question Time.